Good evening, this is Laws 11046, Law and the Environment. It's week number 6, and this week the prescribed reading from Jerry Bates' publication Environmental Law in Australia is Chapter 3, which deals with environment protection and the common law. Before we start that, just a few comments about the first assignment. Overall, I was very pleased with the work. The purpose of the assignment was twofold. Firstly, in relation to case law, to determine what are the important principles for a court to consider in coming to its decision, and also, importantly, how the court structures its judgment, which is very similar to the way that we ask you to write legal papers. You'll recall discussions of the IRAC method, and you'll see that type of writing in the writing of His Honour in preparing that judgment. Also, if you're having concerns or questions about how to reference material, have a look at a judgment like John or the text, and you'll see plenty of examples of, I guess, the Australian Guide to Legal Citations form of referencing, as opposed to Harvard. All right, the assignment, I think, generally was done very well in terms of case law. The second part of the assignment was dealing with legislation and showing the way in which policy discussions are translated into legislation, which ultimately became the Vegetation Management Act. The purpose of inviting you to have a look at Hansard is you could see that transition from policy through to legislation. Perhaps one thing which wasn't obvious is that in a way the loop wasn't completed, in that in many instances, once legislation is passed, it will override the common law previously created. That wasn't really particularly the case in relation to vegetation management, but that would often be the case generally. All right, so overall I was very happy with the results of the assignment, and I think everyone did very well. Before I move on, are there any questions in relation to the assignment, anything that you want to discuss more generally? You can use the chat facility, or you can come in live and ask a question. All right, now, as far as the exam is concerned, you will be asked to answer 5 of 7 questions. The exam, as I recall, will be for 3 hours. I believe you now know the date of the examination. I think that information was released. If anyone has that date, please let me know. You will be asked to answer 5 of 7 questions. Now, I have written the exam, and the exam is open book. What that means is that you can essentially take whatever you like into the examination. There are a few things you can't. You can't take into exam a calculator, which you won't need. But importantly, you won't be able to take in anything which will allow you access to the internet. Now, for those of you who have a digital textbook, that creates an obvious problem because you won't be able to access that digital textbook. So some sort of arrangement will need to be made. So thinking beyond that, what can you do? What can you take into the examination? Well, if you like, you can take in your complete answer and simply rewrite it in the examination. The examination is, of course, all written. If you have some particular disability that would make it difficult for you to write, then an application through the appropriate channel should be made in that regard. But assuming that you have no problem in writing, and don't be concerned about handwriting, I can read it and decipher it pretty well. So there hasn't been a student yet that has been able to confuse me with the handwriting. So don't be too concerned about your particular handwriting. Most important thing is to get it on the page. But what you can do is essentially write your answer, have it typed, and then rewrite it in the exam if you want to. That's if you're prepared to guess what the question might be. You can certainly take in your textbook, you can take in case law, you can take in all sorts of written materials, but remember, of course, and this is very important, that the plagiarism rules still apply in the exam context. Now, of course, I don't have the benefit of Turnitin as the computer program to look at that, but I'm pretty familiar with the material, so it pays to reference the material. Now, I don't expect it to reference in accordance with the Australian Guide to Legal Citations type of footnoting reference. Some sort of Hansard style reference is fine in the examination, as it is for the course generally, but just in case you're wondering what type of referencing we need in that exam. So we've concentrated already on a few areas that might be of interest for you to study in particular, and it's probably fair to say that tonight is no exception to that general rule. So speaking of tonight, the prescribed reading was Chapter 3 of Bates, which deals with the topic of environment protection and the common law. We've dealt with some of these issues already in many ways. And I guess the thing about the common law is that it did protect property owners' rights as it was seen in the law to a great extent. In other words, there was no common law principle of protecting the environment. There was no common law principle of protecting the interests of the public generally. The common law was all about protecting proprietary interests of landowners. I guess another reflection about the course so far is that you've seen that there are, in some ways, I guess, three different concepts of what is the ownership of property. The first, which is the Indigenous view, is that essentially the land is there to be shared and it's a collective resource available to all, and that people don't have an individual claim or stake in land, that it is there to be used, and that everyone, in a sense, is licensed, to use the later terminology, to use that land. So that's at one extreme. At the other extreme is the concept that a landowner owns the land and all of the resources below that land and all of the airspace above it, and has absolute right to do with that land as he or she sees fit. So that's at the opposite side. Realistically, we're somewhere in the middle. Even though we have great parcels of land in Queensland and elsewhere, which are through deed of grant provided to individual owners to be held in fee simple, which is the highest form of ownership of property that we have in our system. That doesn't mean that the owner can do anything they like, and it doesn't mean that they own everything above and below. So below, of course, you'll recall from previous statements, the deed of grant, which provides the original grant of land, carries with it a reservation to the Crown in relation to things like petroleum and mineral exploration and exploitation. So even though you might own the land, that doesn't mean that someone can't have a mining permit or petroleum permit to deal with the the resources which are subterranean. So we've got that that distinction. As a further, perhaps, sub-distinction from that, with the introduction of environmental law legislation, we've seen an erosion on the way in which people can use the land that they have. Now, I'm not talking here about the resources below or the airspace above, but the actual surface of the land. So at common law, the protection was always to allow the landowner to essentially do what he or she wanted with that land. Now, that's becoming progressively less the case, in that there is a much greater emphasis through environmental law on the common good and the environment generally. Now, what's interesting about that, I think, is that through environmental legislation, we are not going as far as it was in Indigenous Australia before white occupation, but we are moving towards that, in that there's a recognition that there is the public interest, there's the public good associated with your ownership of land. So what you can do with your land through environment law and planning law is becoming essentially more restrictive to take into account those larger issues and the public good generally. All right, are there any questions about what I've said so far? Please jump in live or ask through the chat facility if you wish. So Chapter 3 is all about how environment protection works with the common law and deals with that essential conflict between the interests of environmental protagonists and property owners. So legislation can now restrict landowners so they can't necessarily do whatever they wish to exploit or degrade resources on the land. The public good must be considered. When dealing with the issue of property, bear in mind that there is the distinction between the owner of the property, which is fee simple, as I mentioned before, and those that have some other form of interest in the land. I've mentioned already the Crown, which has the interest in petroleum and minerals and resources which are subterranean. But on the surface, there may be other people who have an interest in that land. Some have a legal registered interest. It might be in the form of a lease or an easement. And there are those that have some sort of proprietary interest, and that's the type of proprietary interest we're talking about, as opposed to those that have some sort of permissive interest, which is normally in the form of licensing. Where that becomes interesting and relevant is in terms of the issue of compensation, should those interests be taken from the person who holds them. So, as we've talked about before, courts have typically, through the common law, been the champions of the interests of the landowners, and part of that, part of the, I suppose, the byproduct of that is that courts then take on a role of acting to ensure that there is not a bureaucratic excess in terms of administrative decisions made about that property. So in other words, the common law courts, as champions of the rights of the owners of property, guard in some ways against the involvement of the executive, the second tier of government, in coming in and making decisions which affect that landowner. And that might be in all sorts of different ways. All right. Now, as a property owner, you can't do whatever you like. You must do so bearing in mind the issues regarding tortious liability, which might be nuisance or negligence, or perhaps trespass. But in addition to that, we have the statutory issues that come into play. Now, where there is a statutory prohibition or restriction or direction which is affecting a property owner, then should that property owner breach the regulations, then they may, of course, be liable to prosecution. In those circumstances, the question might be asked, if the property owner was authorised to do a certain activity, will they then be liable under, say, common law nuisance, or by breach of prosecution, or through prosecution in pursuing a statutory entire matter, or can they use the defence of statutory authority? So the question which is raised in the text is then, if someone has a permit to develop or a licence to do something like emit pollutions and pollutants, are they automatically able to say, well, I had a licence, I had permission to do it, so therefore I'm not liable at common law from from claims by my neighbours? So parliaments have been generally willing to exempt statutory authorities from the consequences of their own actions, provided those actions were done in good faith. But as far as landowners are concerned, private landowners, they're in a more difficult and more risky, I suppose, a riskier situation, in that even though they might have the authority to emit pollutants, it doesn't necessarily exonerate them from a claim from their neighbour who suffers damage as a result of their actions in the tortious claim of nuisance. So the point that I'm trying to make is, don't necessarily look at what appears to be the overall situation through the issue of a licence. Be prepared to consider that there are still constraints which might be imposed on the licence holder over and above the terms of the licence. They still have a responsibility to their neighbours in a general tortious sense. Now, when it comes to dealing with policymakers, they may well have an exemption from liability as a result of the defence of statutory authority. Climate change is going to have an enormous effect on this, and the question will be, can the policymakers excuse the negligence of statutory authorities in circumstances where they've been trying to deal with this issue of climate change? So it may be, for example, that statutory authorities, in all good faith, attempt to implement a system which will hopefully resolve certain issues, real or prospective. But what if things fail? Will they then be liable for unsuccessful experimentation in the type of work that they do? It will be a matter of either burdening the authority with any loss that's suffered as a result of those circumstances, or burdening the individual, if in the case of an individual landowner, or perhaps through statutory schemes trying to spread that financial cost among the community generally. So there are a lot of policy issues that need to be considered as environmental change comes into fruition in a real term. I just want to mention something about tortious actions. When we talk about torts, that's that series of law which deals with such claims as negligence, nuisance, defamation, things of that nature. So it may be that sometimes the situation is reversed and the landowner makes a claim against environmentalists and protesters in circumstances where they have been trying to legitimately protest against some sort of proposed development. And the acronym which comes to mind is SLAPP, S-L-A-P-P, which it's a SLAPP action is stands for Strategic Litigation Against Public Participation. And the whole idea of a SLAPP action is to shut protesters down because they get caught up in very costly and very lengthy litigation, which is risky, because if they take on some litigation and lose, they may then well suffer a costs order, meaning that not only do they have to bear their own costs, their own legal costs and other costs, but they'll be subject to an order to pay the other side. So environmentalists and protesters can sometimes find that it's not criminal sanction that will cause the difficulties that they face, but rather a common law action against them, which might be a real action, or it might simply be a SLAPP action to essentially dissuade them from pursuing the matter any further. All right, so have a look at the commentary in Bates chapter 3. Try and understand the difference between different types of property rights. Understand the key to environmental law is the fact that landowners cannot necessarily do whatever they like. They are subject to environmental legislation, regulations. Try to understand the difference between proprietary and permissive interests, that is the legal interest versus perhaps something which is a license only. And think about the way in which common law actions can be used both to attack the alleged perpetrator of environmental damage, but also by the industry against the individuals that seek to oppose what is being done. Have a look also at this defence of statutory authority, and as I said, the statutory schemes for liability also come into play. All right, so that's a very brief overview to supplement the more formal overview of Chapter 3 of Bates. And as I mentioned, it would be worthwhile studying that chapter very carefully for the purposes of the exam, I should think. All right, I just want to talk briefly now about statutory schemes and innovations. No questions at this stage, right? So, as I mentioned before, certain natural resources, minerals, are reserved through the deed of grant and remain in favour of the Crown. And you remember we talked about this concept of the Crown, if you like. It's not the government, it's not the people, it's kind of like the household on a national scale. So certain natural resources such as water allocations are granted and controlled by the Crown, and there are statutory schemes put in place which provide the administration needed to, I suppose, rationally distribute those resources for individuals, for different individuals and also for different uses. So the statutory schemes affect the owner's rights at common law by denying them the absolute right to use those resources under the ground, but also perhaps flowing through the ground. So water, as I mentioned, is something which is a natural resource, now controlled essentially by the Crown through statutory schemes. So progress has been made in applying concepts of property rights to environmental issues, for example, in relation to irrigation, and some of the statutory schemes involve water trading. The entitlement to compensation in circumstances where a person says they've been deprived of an interest or a resource that they had previously had the benefit of will often be determined by reference to the legal status of the entitlement. For example, if someone has a mere licence, which may or may not be transferable, then they're not likely to be in a position to obtain benefit or recourse under a statutory scheme. Whereas a person that does have a proprietary interest through lease or license, through lease or easement, for example, may well have an entitlement to seek compensation under a scheme. So you need to be aware of those differences for those reasons. Another area which is regulated through statutory schemes is the area of fisheries, and the entitlement to compensation will often be determined in circumstances where there are question marks about the issue of cheating. For example, fisheries, there may be issues regarding people avoiding the system through the use of black marketing their products or processing products at sea, and that's something that needs to be considered as well. All right. One of the purposes of the first exercise, the assignment, was, as I mentioned before, to show how policy is translated into legislation. And in the case of the Vegetation Management Act, we saw that the law, as was passed, reflected the policy adopted by the government of the day. And in that regard, public sentiment does play a role. And in that case, we saw calls to support farmers and provide entitlements to compensation were put forward as being in the public benefit as well as in the private private benefit of the individual landowners. So when it comes to the question of compensation, let's say in the case of farmers, if there's a restriction on property rights, then there is that general policy rule of whether they ought to be compensated, not necessarily because of legal rights or entitlements, but because what they were doing was designed to deliver benefits to the community as a whole. So lobby groups have a huge part to play in these types of issues. All right, that's probably all I propose to talk about in terms of Chapter 3, and in particular the statutory schemes. Are there any questions? All right, so for next week, week 7, I'd like to make sure that you read chapters 8 and 10 of Bates, and I'm very keen to see more involvement from more people in terms of UCREW. By all means, ask questions through UCREW, make comments, provide links to things that you think are important to be shared. And you should also be now mindful of the second assignment, which is due, and really start to think about the examination in earnest, what you're going to write in relation to certain questions. So I wouldn't leave you thinking and the thought process and planning to the last minute. Do that well in advance of the exam. And open book exams are great in that all the information is there, but of course, because that is the case and you have the resources, you are marked to a higher standard than you would be in circumstances where it was simply relying upon your memory to provide the material. Okay, thank you very much for listening. If there are no other questions, I'll stop the recording now. Thank you, and we'll see you next week.